and sweet, or as short as possible. Today we're talking about court and jurisdictions, and how you can get out of it. The first court you attend is called an arraignment, in which it's the court's purpose to find out what your intention is in regards to your rights. They intend to find out if you're going to stand up for your rights or be a fearful coward. During this proceeding, the judge will inform you of the charges formed against you. This is the court's way of trying to get you to plead guilty or not guilty, or as a third option, no contest, which is essentially pleading guilty but without admitting guilt. However, take caution here, because the moment you open your mouth to enter a plea, you are giving the court jurisdiction over your rights. If you intend to follow this procedure and win, you must not enter a plea. When you are first called to see the judge, his first question to you should be somewhere along the lines of, do you understand the charges against you, or how do you intend to plea? You must then respond as, no, I do not understand, or cannot enter a plea until you have some questions answered. At this point, it is most likely that the judge will be irritated and try to intimidate you. And you respond and politely state that you must have some questions answered before you can enter a plea. Explain to him that you do not understand the nature and cause of the actions held against you. Once the judge has agreed to answer your questions, your first question will be, is this going to be a civil action or a criminal action? In the extremely unlikely chance that the judge responds saying that you will be held against civil action, your response will be, thank you, Your Honor. Let the record reflect that this will be a civil action. Your Honor, since this is a civil action, I make a motion to dismiss the case for the lack of a sworn complaint in an injured party, and there is no injured party present. Or, on the other hand, the more likely case is the judge will state that this is a criminal action, in which case you promptly respond, thank you, Your Honor. Let the record of this court then show that the action held against me is a criminal action. And now I have another question. Your Honor, the Constitution grants this court two different criminal jurisdictions. One is the criminal jurisdiction under the common law, and the other is admiralty or military tribunal venue from Article 1, Section 8, Clause 17 of the Constitution. In which of these criminal jurisdictions does the court intend to try me? Now, don't panic if you do not remember the article, section, and clause. If you do not, please have a piece of paper and notes to write it down, and make sure to have it with you in court that day. You should have them down by the time you have practiced for your court date. When the judge then provides a specific answer, you then say, thank you, Your Honor. Then let the court record show that the criminal action held against me is under the jurisdiction of, and enter whatever jurisdiction he stated. However, do not expect an easy answer for that question, for you have just exposed the court's fraud. Because the fact is that they're acting under a military tribunal, which of course they have absolutely no right to use with you. But the judge can't say that, and the judge can't also say common law, because if he does, you will make a motion to have the case dismissed for lack of sworn testimony and injured party. Exactly like we did when he said it was a civil action. When you protest that there is no injured party, if the judge is silly enough to then state that the state, whichever state you're in, is the injured party, you then say, Your Honor, I make a motion that this case be dismissed. We are in the wrong court. If the state is a party to the case, they cannot also be the judge and prosecutors. There is a conflict of interest, and this must be taken to a federal court, or be dismissed. But the more likely of the scenarios, the judge will try to avoid answering the question and tell you to seek legal counsel from a licensed attorney. If this is the case, your response should be, thank you, Your Honor. But I don't think you'll be violating your oath of office if you did your duty under the Constitution. You see, I am not seeking legal advice. What I want to know is legal intent. I have the right to appear as myself in my own person, without a licensed attorney, and in order to intelligently defend myself, I have to know the jurisdiction that this court is operating under, because the rules of a criminal proceeding under a common law jurisdiction are very different from the rules of criminal proceeding under the admiralty jurisdiction or military tribunal. I need to know which jurisdiction you intend to try me under in order for me to proceed to defend myself in this case. The Sixth Amendment grants me the right to know the jurisdiction that's being applied, and it grants you the duty to inform me, and I don't think you'll be violating your oath of office by doing your duty. Therefore, can you please answer the question so that this court is properly identified and I can properly defend myself? Now, if the judge continues to respond by telling you you still need to seek an attorney, your answer will then be, thank you, Your Honor. Then let the court record then show that I, insert your name here, the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation under the authority of the Sixth Amendment, and that this court has failed in the duty to inform me of the nature and cause of the allegations sent forth. Furthermore, let the record show that this court intends to bring this further action against me under a secret jurisdiction only known to that of the judge and licensed attorneys. At this point, the judge may claim that this is a statutory jurisdiction, under the statutes of the state of whatever state you're in. If he does so, your next statement should be, "Thank you, Your Honor. Let the record of this court then show that it intends to conduct a criminal action against me under a statutory jurisdiction. And Your Honor, this raises another question. I have never heard of such a thing as a criminal action held against on a statutory jurisdiction, and there is no such jurisdiction established under the Constitution. I will be happy to accept this, Your Honor, if you can please tell me where I can find the published rules of criminal procedure under a statutory jurisdiction. It is imperative that I have the published rules and procedures so that I may conduct a fair defense in a fair trial. Now, keep in mind, the judge made up this jurisdiction. There is absolutely no granted authority for a statutory jurisdiction, and certainly no published rules. But don't expect him to tell you that. He is left with the choice of lying, entering a plea on your behalf, or dismissing the case. At this point, the judge may even threaten you with contempt of court. If he does proceed in this manner, you simply state, "Your Honor, I do not wish to be held in contempt. I am simply trying to exercise my Sixth Amendment right, that you disclose the nature and cause of the charges against me. I can provide court citations that show that the exercise of a constitutional right cannot be converted into a crime. So please either identify the properly identified jurisdiction, or I make a motion that you dismiss the case against me." Now, in the least most unlikely scenario, the judge may be honest about the question when you asked which jurisdiction is applied, and will tell you that it is indeed an admiralty jurisdiction. If this happens, you respond simply, "Thank you, Your Honor. Let the record of this court then show that this court intends to proceed with a criminal action against me," insert your name here, "as a condition of contract under the Admiralty jurisdiction and military tribunal under Article 1, Section 8, Clause 17. However, Your Honor, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered into any international contracts, so I deny that any such contract exists. Would you please instruct the prosecuting attorney to inform this court if there is such contract, and if so, to place it into evidence, and explain how I am party to it and compelled to conform under it? If the prosecution cannot do so, Your Honor, I make a motion that we have this case dismissed." And of course, if at any time your case is actually dismissed, make the pronouncement, "Thank you, Your Honor. Let the court then show that case number," enter your case number here, "against," insert your name here, "has been dismissed. Now, leave quietly, save your gloating till after, and know that you've won."